Officer Dave, would you open the courtroom for us, please?
The state of Michigan 36th District Court is now in session with the Honorable Judge David S. Robinson Jr. presiding. Court is now in session. Good morning, everyone. Good morning, Your Honor.
Morning. Hello?
Hello.
What is your name?
Michael Fergustrom, Your Honor.
Okay.
I apologize for having to appear by phone. I have a Wi-Fi issue this morning.
Things happen. Ms. Porter's here. Let's get started. Where'd she go? Oh, there she is. All right, let's get started. This is file 22-182021, Affiliated Diagnostic versus City of Detroit. Date and time for a motion for summary disposition filed on behalf of City of Detroit. Your appearances.
Patricia
Good morning,
Porter.
Your Honor.
Oh, I'm sorry. Go ahead.
Excuse me. Good morning, Your Honor. Michael Fergustrom for the plaintiff.
Bar
Number 48864.
Good morning. Patricia Porter, P66989 for defendant, City of Detroit.
Ms. Porter, I believe this is your motion for summary disposition.
Yes, it is, Your Honor. And we filed it because the Register of Actions says the complaint was filed on March 21st, 2022. The dates of services were 3/10/2021. So more than a year went by before the complaint was filed. And there is no tolling under the no-fault law because there was no notice prior to the complaint being filed. So in order to toll under the new revisions to the no-fault law, you have to have provided notice or a claim. And we have the affidavit of Sherry Peterson that says no notice was received until the complaint. The complaint was our first notice. And there is no tolling, as you requested some guidance on tolling under the COVID pandemic order. And that order I supplied in a supplemental pleading that stated that it expired and the order was rescinded on June 20th, 2020, and before the suit was filed on March 21, 2022. So that tolling doesn't come into play. So based on that information and what's before the court in terms of proof, I believe that we are entitled to a summary disposition on the 1-year back rule.
Counsel for defense, you're done?
Yes, Your Honor. Well, regarding the tolling issue, Your Honor, the statutory tolling now provides for 1 year after the claim is denied. But in this case, that's not even really the main issue. The main issue here is that this complaint was actually filed on March 1st. We've had this issue come up several times with the clerk of the court's office, in which we have filed the complaint, but it has not been recorded or summons issued and sent to us until several weeks later. But the operative date for any sort of limitations is the date of filing, and not the date that the clerk's office, whether because they're short-staffed or whatever, manages to get the summons issued. This is not the first time we've had this happen, but we have submitted a document showing that it was actually filed on March 1st, not the 21st, and March 1st is within a year of the date of service. At a minimum, there's a genuine issue of material fact there, but realistically, maybe not even an issue, and because I think that it is clear we filed it timely, and the date that the clerk issued the summons is not the operative date. The date that the complaint was actually filed is always the operative date for timeliness. And therefore, Your Honor, summary disposition should be denied.
Ms. Porter?
I would only say that I see no proof other than the complaint itself, which I submitted, and I find that date illegible. But if the court can figure it out from just the document itself, I see no other proof, no affidavit saying when it was filed, then I would rely on the court to do that.
Well, the problem, I think, is that we are having a question about what it does filing mean. That's really the issue here. Counsel for the plaintiff has, as part of his responsive pleadings, filed a copy of a face document just for the complaint here, which shows to the court's reading a March 1 filing date. The register of action indicates that the date of filing was March 21st of that same year, 2022. The court is going to find that there is at minimum a genuine issue of material fact here as to the date of filing. The stamp that I see on counsel's complaint is a stamp that the court recognizes as being regularly used in the course of business here at the court to log in documents when they are received. Looking at the date back in March of 22, we were still recovering from the COVID, and there was a lag time in many cases between the date that the pleading came into the court, and that's what this date of filing stamp means, and the date that it got to the clerk, because the process is when it comes into the mail room, it is stamped, but it is not deemed to be filed until it goes to the clerks through the cashier and the filing fees are paid. So in this case, it appears that there's at minimum a genuine issue of material fact as to whether or not we had the complaint in the court filed by the plaintiff more than 1 year prior to the date of the filing of the complaint. And for that reason, because I am required to be a liberal in finding the existence of genuine issue of material fact, I'm going to deny the motion for summary disposition. It appears pretty clear that the court did have in its possession and had registered as having in its possession the complaint more than 1 year, prior to the 3/10/22 anniversary of the only date of service. So for the reasons set forth on the record, defendant's motion for summary disposition will have to be denied. Now, how much money are we arguing about here?
I believe it's 3 MRIs, Your Honor, if I remember correctly. I don't have Wi-Fi right now, but I think it's something like $13,850, something in that range.
Okay, you guys have made the 2.302A disclosures. Let's get started on resolution on the file. I will send out to you today an order denying the motion for summary disposition. Our next date will be April 21 at 10 o'clock. Does that work for everybody?
I'm
Yes,
sure
Your
we can
Honor.
make it work, Your Honor.
Okay, thank you both for coming in. We're off the record.
Thank you,
Thank
Your
you.
Honor.
Let's be
Have a
safe.
good day.
Y'all be safe. Thank you.
All right, you too.
Mr. Cox,
Good morning, Your Honor.
Mr. Mazie.
Good morning, Your Honor.
This is 22-192-621, City of Farmington Hills versus Annalise Thorns. Date and time for a motion for summary disposition filed on behalf of plaintiff City of Farmington Hills. Your respective appearances.
Good morning, Your Honor. May it please the court, Keith Cox of Winters and Associates on behalf of the plaintiff P59146.
Good morning, Your Honor. Scott Mazie, P48693, on behalf of the defendant, Annalise Thorns.
Mr. Cox, your motion.
Thank you, Judge. We brought the motion this morning pursuant to MCR 2.116 C9 and C10, as we don't believe there are questions of material fact or valid legal defenses having been raised by the defendant. It's a pretty straightforward ambulance case, Judge. My client transported the defendant back on the date in question, April 18th, 2021. The cost of the transport was $754. To my knowledge, the defendant doesn't dispute the fact that she was transported and received the medical care, the cost of the care, the fact that it remained unpaid to date. The only thing the defendant seems to have raised as a possible defense to this action is I had valid health insurance. Set forth in our brief that we did my client that, and I think the defendant conceded she didn't give the insurance information on the date the services were provided. My client attempted to bill Medicaid. There was no active Medicaid. They sent statements to her in an attempt to get the insurance information. They haven't been able to get it in a timely manner. But the existence of insurance as illegal is not a legal defense to plaintiff's claim. So on that basis, there hasn't been a legal defense raised under C9. And under C10, I think basically all the material facts that are necessary to advance plaintiff's claim are not in dispute. And frankly, Judge, we attached the run report, a redacted version of the run report to our motion, trying to leave out the medical record portion, but those appears to have been waived because the defendant attached the entire report to its response. I'd also note that our motion is supported by an affidavit from the plaintiff as a C10 motion. I didn't see a counter affidavit filed on behalf of the defendant. Consequently, I think we have a prima facie case relative to the issues raised in the affidavit or the amount in controversy. And we'd request the court grant plaintiff's summary disposition motion. The one thing I would indicate is that this week, defense counsel reached out to me and said they're making another attempt to try and get insurance to pay this claim. Obviously, plaintiff wants insurance to pay if it can. And I did represent to counsel this morning that if the court grants our motion for summary disposition, I would be agreeable to either holding back, submitting the order, submitting it under the 7-day rule in 45 days, or alternatively stipulating to not collecting on the judgment or the order entered by this court for a period of 45 days to allow a final bite at the apple. But plaintiff's not agreeable to slowing the case down or not proceeding with the motion this morning on the basis that they're trying to make another run at insurance.
Mr. Mazie.
Yes. So my client had a procedure done outpatient and had complications, as I indicated in my answer in my brief. I spoke to my client's grandmother, and she was present at the surgery as the driver for her granddaughter, who was the defendant. She had indicated to me she tried to get the surgery to be done at the hospital itself because of several pre-existing conditions of the defendant, but the doctor refused to do it at the hospital and wanted to do it at the outpatient office. And then these bleeding complications arose. The doctor's office is the one that
points out that the doctor was right, doesn't it? The whole purpose, I mean, you got this done, you got it done. Are you disputing? Let me just cut to the chase here. I take it you do not dispute that your client was taken in an ambulance on the day alleged in the complaint and that the bill was $754. Your argument, as I understood your pleadings, is that your client had insurance, and had there been a correct billing of the insurance, this lawsuit could have not proceeded because the insurance company would pay. Am I correct on the facts?
Yes, and in addition that the letters that were mailed out by the collection agency on behalf of Farmington Hills did not have my client's correct address until after 1 year from the date of the ambulance rides, which the 1 year time frame. And also my client would have submitted the bill to her own insurance if she had received a letter indicating that she had a bill coming.
Well, first question, correct me if I'm wrong, but my understanding is that the statute of limitations on contract cases like this is 6 years. Is that correct?
Yes,
So let us assume that things are as you say, and the letters were sent by the collection firm to the wrong address. There would have been nothing to prohibit the plaintiff from bringing his lawsuit 5.5 years after the date of service, would there? He has 6 year period of limitations.
as far as the plaintiff suing the defendant individually,
Yes.
correct. Yeah.
Well, that's where we are. The plaintiff is suing the defendant individually.
Yes, sir.
So the fact that the billing agency billed the wrong address, how is that relevant here?
Well, I guess the insurance has a different timeline than statute of limitations wise. They want bills to come within a year.
Okay, that might be in between a claim between your client and the insurance company. But this is not a claim between your client and the insurance company. This is a claim between the service provider, the ambulance service, and your client. Am I failing to understand here?
Yeah, that's correct, Your Honor. So my client did receive the ambulance ride. She was not the one that called for the ambulance ride. It was the doctor's office that called for the ambulance ride.
And the ambulance ride was for your client, and she did in fact ride in the ambulance.
Yes, sir.
Okay, so we're not disputing that plaintiff rendered ambulance services to the defendant.
Correct.
I have seen nothing to dispute the claim by the plaintiff supported by the affidavit of one Jason Ozuski, who describes himself as deputy fire chief, that the charge here was $754. Have I missed something in that regard?
No.
I have not seen any argument that your client has paid the $754. No one has paid. Is that also true?
Yes.
Okay. All right, the court's prepared to rule. The problem here is that I'm going to rule under MCR 2.116 C10, no genuine issue of material fact. I am required to be liberal in finding the existence of genuine issues of material fact. But everyone concedes the following. On the date alleged in the complaint, plaintiff gave ambulance services to the defendant. The charge for those services is $754, and that charge has been unpaid. Now, it may very well be that that defendant has some other alternative method of payment by way, perhaps of insurance, maybe a friend or whatever. But in terms of the motion for summary disposition, I would also note the defense is, and I'm quoting now from your brief, then this bill would likely have been covered. Quoting from your brief. If plaintiff had defendant's correct address and she received the plaintiff's billing, then the billing could have been submitted to defendant's Blue Cross within the proper time frame to get it paid. Defendant continues to try to get it paid. The fact that there may be insurance available under Blue Cross Blue Shield, or the fact that it may be too late to make a claim for the insurance under Blue Cross and Blue Shield, is not legally relevant here. The existence of a third-party payer is not legally relevant on the issue before the court today. It's undisputed that the service was rendered, the cost of the service is unpaid, the amount of the service unpaid. Therefore, plaintiff's motion for summary disposition is granted under MCR 2.116 C10. Of course, Mr. Mays, you have an absolute right to appeal my decision. That appeal must be perfected within 21 days of the date of the entry of the order. Now, Mr. Cox, if you want to submit an order under the 7-day rule, providing there will be no collection efforts in regard to this bill for 45 days from the entry of the order, that'd be perfectly fine.
That's what we'll do then, Judge.
I need an order Or otherwise, I'll handwrite my order out today.
Okay, I'll submit one under the 7-day rule, Judge, that contains that language. And again, just for purposes of Mr. Mays' benefit, if my client will try to work with her to the extent possible to get some additional payment from a third party, but and we'll hold off for 45 days to see if something results. But I'll submit that order to the court. I'll put that in today's mail, Your Honor.
Thank you, gentlemen. Appreciate
Thank
you
you.
coming in. Let's be safe out here.
Thank
Thank
you,
you.
Judge.
We're off the record. Him. And Mr. Schaffner. Two 807. All right, gentlemen. This is file number 22196805. Acuity versus U.S. Refrigeration Incorporated. Could I have your respective appearances?
Yes, Your Honor. For the record, Albert Kim, P70301, appearing on behalf of plaintiff in this matter.
Your Honor, Keith Schaffner, on behalf of the defendant, U.S. Refrigeration.
You remember the State Bar of Michigan, Mr. Schaffner?
Yes, Your Honor.
You probably have a P number.
P41852.
Okay, gentlemen, this is our first pretrial. I opened on February 24th, your written discovery. How are we doing on that?
Your Honor, we have been going back and forth. This is a collection matter with regards to a workers' compensation insurance premium. I think we're just trying to get an audit redone on this matter to see if we can possibly lower the balance on it. Opposing counsel and I are working well together. We have been communicating. I think we just need a little bit more time to get some more documentation, and hopefully we'll get this wrapped up for you.
Gentlemen, let's continue then your written discovery. Have you back April 21 at 10 o'clock. Does that work for everybody?
That should be fine, Your Honor.
Yes, Your Honor.
All right, y'all be safe out here. I'll send
Thank
out
you,
a
Your
line.
Honor. Good seeing you again, too.
21st. Let's be safe, gentlemen. COVID's coming back up.
Understood, Your Honor.
Sad to
Thank
be
you.
said, true. Thanks for coming in, guys.
Be
Thank
well,
you.
Your Honor.
Good to see you. April 21 at 10 o'clock.
All right.
Thank you.
Appreciate you
No
coming.
notices will be coming, Your Honor, I'm assuming.
Oh, no,
based
I'm
on
gonna
your-
mail it out.
Okay,
In fact, when I get off here, if you stay on, you can watch me write it out.
okay. All right, thank you, Your Honor. Be well.
Thank you, Your
Thanks,
Honor.
guys. Appreciate you coming in. We're off the record. All right. Ms. Fraser, good morning.
Good morning, Your Honor.
You've got Darius Bosket versus Experian.
That's correct.
I don't have Mr. Bosket as of yet. He gets a few more minutes and then we'll dismiss his file.
Okay.
Put you back in the waiting room, get back to you in a couple minutes.
All right. I'll be here.
Thank you. Mr. Rusin, good morning.
Good morning, Judge. How are you?
I'm good. And you?
Oh, just, a lot of chamber work today.
Yeah. Well, I don't have Ms. Gibson as of yet. We'll give her a couple more minutes and it's default time.
All right, I'm ready to go when you are.
I'll put you back in the waiting room. We'll get you out and get you move on your way.
All right, thank you.
Thank you. All right, let's go. We are on the record calling file number 22243549, Darius Bosket versus Experian Information Solutions Incorporated. This matter was initially commenced by the filing of a complaint in the Small Claims Division of the 36th District Court and was removed to the General Civil Docket. Could I have your appearance, counsel?
Good morning, Your Honor. Tamara Fraser appearing on behalf of defendant Experian Information Solutions Incorporated.
Your bar number?
P 51997.
By a notice dated February 24, 2023, and sent to both parties on that date, this matter set for pretrial today, March 24th at 10 o'clock. It's now after 10:30. Defendant has appeared. Plaintiff, however, has failed to appear. No good cause of that failure having been shown. The matter dismissed without prejudice. We'll send you out an order today, ma'am. Thank you for coming in.
Thank you, Your Honor.
Have a great day and let's be safe.
You too.
Thank you. We are on the record calling file number 23141-294. The file is entitled LVNV Funding versus Kerry Gibson. Could I have your appearance, please?
Judge, may it please the court, my name is Attorney Richard Rutzen. I'm the attorney of record for the plaintiff. I'm also the attorney of record for the plaintiff today in this pretrial conference.
This matter is before the court today following a notice setting it for pretrial. That notice was sent to the parties on February 24th, 2023, setting the matter for pretrial today, March 24th at 10 o'clock. It's now after 10:30. The defendant has failed to appear. No good cause for that failure having been shown. The default of the defendant is hereby entered. We'll send out our order today. Thank you for coming in.
Thank you, Judge. I rest.
All right, let's be safe.
Thank you. Bye-bye.
Off the record.
So great to have got our as our international guest today too. Got our introduced this January. So it's Christ's second full year. This deal, so is it very it's infectious condition. Really a close relationship with the district and he's a jazz patient on himself. He has the person himself. So what a great program we have this morning. I program this week on this name with them. So I would say, what's not about the rock bottom of the average is most things demonstrate. Just shut the block of great teams. We're going to hear Gutter being really talking about. He loves this piece so much, and what are his favorite pieces? I really want to know that. That is romantic era of the so I learned and many others. It's very nice. There's two different generations, so we're going to kind of go back into 75 before the same he is really all the same generation. So then you go back. Yeah, we're beginning with this and then talking really an under and his magnum opus which Samuel Woolridge Taylor Foundation says is Woolridge Taylor's concern with fairness students is seen that into engaging whilst Victorian wanted was more various some of the Taylor nonetheless knew firsthand both from discrimination by race and objective this website dedicated to saying and it's also Taylor's involved in allowed tourists to back said to build events focused on how breakfast and address these things. It's interesting of time where I know that music Well, this is at least an academic circle, so. And how we. And music, experimenting. And this. Here we are. And again, thank you to all of our listeners from the state of Michigan of listening on our WRC network. Also our listeners in Southern California on AX. And for the folks also listening online on the app. And there's no problem with your internet connection. Your link is there and so riches service. All right, we've had our beat for 40, there you go, or 41, whatever it takes. So God gave you. So today we have a great romantic project for all of you. We have Matifizer. We have the Ballad by Coleridge Taylor, a very interesting and sparkling piece with a beautiful melody in the middle. And then we have Rachmaninoff and Brahms. We are both part of the romanticism. Actually, the late romanticism. In romanticism, music changes.
Ms. Ronk, good morning.
Oops, my volume's down.
I'm sorry, good morning.
Good morning.
I don't have the other side as of yet. Have you guys settled the case?
No, but we were talking this morning about settlement. If we could just have a little bit more time, we're like checking out exactly what was done in the other case and what bills are still in play. So we're working towards settlement.
Okay, well, I thought I had both of you here because I heard two rings in my waiting room. But when I got here, you were the only one here.
Oh, he said he's gonna do you want me to just text him to tell him to zoom in right now?
Yeah, we could do that. That'd be fine.
Okay, because we've been going back and forth. All right.
This is a case that hasn't worked out well for either of you.
Well, you know, it just providers hire two different attorneys and
This is a case where city was defaulted.
yeah,
Dismissed when they didn't appear. Sometimes files just go south. I mean, that's just the way it is.
it's been this is my only district court case left, 36th district court. I had like 20, 30 of them at one point. Now that there's not too many provider suits. Let's see. He says he's logging in right now.
Okay. As soon as he logs in, we'll get him in and we'll get you guys going.
Are people coming back into 36th district court like the public now?
Well, we're allowing on the criminal side, people are in.
Okay.
But on the civil side, the Supreme Court, as you will recall, issued an order directing us to do everything we can remotely. And there's certainly no, I can see a pretrial, certainly no reason for people to come in.
Yeah.
I think the only time I'm going to see people in my courtroom, I would expect would be if we have trials, because I don't know how I can judge credibility over a computer screen. But
yeah, I just don't think you can do a Zoom trial. I agree with you.
I tried to do one, and I just had to stop and say, we can't do this. We have to come in because one of the parties wanted to show me something on the screen. And of course, the writing was so small, nobody could read.
Yes.
So, but other than that, I think I anticipate that everything will be done remotely on the civil side because the Supreme Court has issued an order directing us to do that. Lawyers seem to like it. It's
And it'll
more-
stop like a rebirth of COVID, I think. You know what I mean?
Yeah, we can't pretend it's gone away because we don't like it.
Yeah.
Which is unfortunately what a lot of people are doing. All right, I got him here, so let's get started, or here, excuse me. This is file number 20167-228. Complete Imaging versus City of Detroit, date and time for pretrial. Your appearances, please.
Good morning, Your Honor. I'm Museum on behalf of plaintiff P84247.
Cheryl Ronk on behalf of a defendant, 587. I'm not sure, 54897. There you go. I'm sorry.
It
Okay,
happens.
it's Friday. What can I tell you? Okay, so you guys are still working on resolution here. Let's
Yes.
just give you another date and get you on your way. Does April 21st at 11 o'clock work for both of you?
Yes, that works for me, Your Honor.
At what time? I'm sorry.
11 o'clock like today?
Okay, sounds good. And hopefully we'll just get something worked out.
That'd be great.
Thank you.
both for coming
Thank
in,
you.
and let's be safe out there.
You too. Thank you,
Thanks
guys.
for
Have a
coming.
great weekend.
Take care.
Thank you.